Hello, everyone. Welcome to today's session, a webinar on Can EU-Japan Adequacy Decision Be Challenged? I am Deepika Yadav, Coordinator for Digital Trade Alliance, and I would like to welcome you all on behalf of Digital Trade Alliance and Public Citizen. I want to first start with introducing DTA. DTA is a collaboration of organizations working on digital rights and consumer rights issues in Global North and Global South. We collaborate, share ideas, produce research on important issues at the intersection of digital rights and digital trade issues. Today, we are present here to present one such research. Yeah. Yeah.
Yep.
Yeah. And hello, can you guys hear me? Sorry. Yeah, today we are here to present one such research. DTA, with support from Digital Freedom Fund, commissioned one such research. DFF, Digital Freedom Fund, supports digital rights community to advance human rights in digital space. The research that we are discussing with you, presenting to you today, was commissioned to determine the viability and optimal approaches to litigation challenges challenging EU's adequacy decision in context of Japan. So for this research, we engaged 3 researchers who will be presenting their findings today: Professor Hiroshi Miyashita, Professor Svetlana Akvileva, and Javier Ruiz. We also engaged Etica's organization to carry out a small part of the research, which played an important role in the findings. Before we start the webinar, I would like to first share a few more things. One, I would like to share with you that all the blogs and the reports that were produced during this research are now available on the DTA website. You can find the link in the chat box, and I would also like to share screen. Yeah, and show you. Yeah, this is the landing page. Here you can find all the research and blogs that were produced, and they are accessible on the website. Yeah, great. And a recorded version of this webinar will also be available. And I also want to share with you that once we are done with the presentation, we will open the webinar for a round of Q&A from the audience. Over to you, Javier. Thank you.
Thanks, Deepika. So I'm just going to first give you a brief introduction to the project. And then before I let Professor Hiroshi and Dr. Svetlana Yakovleva explain in more detail the work that they did. But just to give you a very brief overview, as Deepika has mentioned, we got the support from the Digital Freedom Fund to look at the viability of the strategic litigation to see whether, specifically around whether the European Union, the European Commission, actually data adequacy decision on Japan that allows unrestricted data flows to that country from the EU could be in conflict with some of the trade commitments that Japan had made to other countries like the US and also countries in the CPTPP. What we found is that this potential conflict of laws created risks and uncertainties, but also in some of the advocacy around digital trade, many people have found that Japan was used as an example of the interoperability of data regimes to say, look, the European Union and other regimes, like, for example, the APEC, the Asia-Pacific framework, are compatible. And the reason why we have why we know is because Japan is able to sign up both to the European regime and to the Asia-Pacific regime, which objectively has lower guarantees, as was found in a bit of research by the European Union a few years ago. So that is the overall research. I think, as we said, like the results are on the website. I will discuss in a little bit more detail. I'll give you an overall summary of the project, but for now, I think that I will let Professor Hiroshi and Svetlana fill you in first, and then I'll try to wrap up and give you an overall summary of what else we found. Thank you.
Thank you, Javier. Over to Professor Hiroshi now.
Well, thank you very much for having me today. My name is Hiroshi Miyashita. I'm law professor at Chuo University. I'm very happy to share my research today in terms of Japan's cross-border privacy rules. I think Japan is a very interesting country that is experimenting global data flow, because Japan has, on the one hand, hold hands with the European Union, known as the most stringent data protection region in the world. On the other hand, Japan has a strong tie in terms of commerce and business with the US, of course, and other Asian countries, some of which has no privacy, the comprehensive privacy at this moment. So I think in terms of academic research, Japan may be very interesting. In terms of geopolitics of Japan, Japan has been shaking hands with many regions, for instance, from the West, EU and the US, and also multiple multi-international fora such as OECD, APEC, and the highest political forum as known as G7. Japan will have a presidency this year and hosting the meeting G7 summit this May, and a separate meeting with data protection communities in June. We do have, by the way, 21 trade agreements, some of which may be contradicting, which I'm going to show later. By the way, the PPC, known as Personal Information Protection Commission, a regulator in Japan, issued a survey, published a survey on data transfer. According to this survey, belonging the 13 global companies exporting their personal data to third countries. 158, some of the companies have multiple groups, so that's why the number is beyond that 113. But obviously, Japanese business climate is more tied with the United States. But the reality is that the Japanese global companies are also exporting some of their personal data to China and other Asian regions, in addition to the European countries. So the story of the experiment started back in January 2019, when the European Commission officially issued an adequacy decision. As I would say, a conditional adequacy decision. Why conditional? There are two conditions. First, the adequacy decision only covers the private sector, private commercial sector. In other words, public sector is out of the scope of the Commission's adequacy decision. Second, due to the several concerns expressed by the EDPB and the European Parliament, the Commission decided against the annual term of 4-year guarantee of adequacy. Japan has only 2-year, very short term of adequacy guarantee in its decision. But the result is that both Japan and the European Union expanded the largest area of safe data flows between EU and Japan. Well, the process, which I also contributed in this process, has begun in April 2006, and it took more than 3 years after all, but successfully reached a mutual adequacy decision between the European Commission. After the adequacy decisions, we saw several data breach, huge data breach cases. For instance, Rikunavi case is a kind of a human resources digital platform manipulated kind of a recruiter's personal data. Because in Japan, as both the EDPB and the European Parliament expressed the concern of the Japanese data protection law, which is completely missing the profiling and automated decision-making under the APPI, at least expressly. And later on, the line case is a kind of a very dangerous case in terms of cross-border data flow. A foreign government may access the personal data, which the Japanese global company, known as Line, as a social media company like WhatsApp company in Europe and the US, access the personal data. The Chinese companies accessed remotely, or they the Japanese Line company trusted their personal data to the Chinese companies. So the Chinese companies were able to access Japanese personal data, and some of the personal data also are stored in a Korean database. In terms of enforcement, both the EDPB and the European Commission criticized the Japanese non-enforcement actions in terms of monetary sanction as a hard law. There was no single case of hard law sanctions since the 2003, when the Japanese data protection law was enacted. 0 cases at this moment, until last month. Even the Line case, the Japanese PPC issued an administrative letter or instruction against Line, and that's all. But the first criminal sanction case was seen last month by the PPC. This is a bankruptcy's personal data located in a Google map. So the PPC initiated a criminal proceeding against this company. But this is the first case. First ever the Japanese data protection law was implemented. By the way, several years ago, I wrote an article on A Tale of Two Privacies, enforcing privacy with hard power and soft power in Japan, comparing the Sony PlayStation Network data breach. In the United Kingdom, the ICO Information Commissioner's Office appealed to the hard power monetary sanction. On the other hand, the Japanese approach relied on the soft law, just issued a public apologies, and the voluntary compensation was seen in this case. I think this is a very sharp contrast in terms of enforcement between the European countries. Of course, the US has a strong tradition of enforcement action by the FTC so far. So when it comes to rules on data transfer, I'm not going to explain the details of it because you can see the blogs. But the Japanese PPC rules clearly relied on the as OECD privacy guidelines as a golden standard of exporting personal data from Japan to the third country. The question is whether the OECD principles, privacy principles are universal, but very flexible to implement in terms of the data transfer. So some countries may rely on accountability, but what the accountability means varies from the corporations to corporation. Who is accountable for what and why accountable? So there are very divergence. There has been a very divergent in interpreting and implementing these basic 8 OECD principles. When it comes to trade partnership, we do have this Japan and EU EPA negotiations started several years ago, and they reached an agreement just 1 week after the Japan-EU adequacy decision. So which is, I think, a kind of political, one may describe. There may be a possibility. The EU and Japan reached an agreement of data transfer in order to prepare for the smooth data trade cooperation between the Japan and the EU. On the other hand, Japan had some complicating economic partnership agreement, for instance, with the United Kingdom, also the United States, and I can give you one example of obvious contradiction with between the the EU-Japan adequacy decision and also trade agreement with the UK and the US. That is the the transparency of algorithm or source code. Both of the trade agreement with the UK and the EU with the United States prohibit to access the source code of software, and both of trade agreement prohibit to access the algorithm, express that in the source code, which might be contradict with the EU data protection regime. That is the prohibition of accessing source code under the trade agreement with the UK and the US may be contradict with the transparency of the logic involved in the data processing, particularly in the automated decision-making under the GDPR in the EU. So there might be a tension, but I haven't seen any practical tension so far in Japan. There is one judgment by the Tokyo District Court in the ranking of restaurants last year. So the ranking should be, the algorithm code of ranking should be disclosed. This is not a trade secret. That's a Tokyo District Court judgment so far. But I haven't seen any practical tension so far. But there is a possibility. But these trade agreements with the UK and the US may be contradicted with the adequacy decision with the Japan, between the Japan and the EU. And this is one concrete example. And I'm an academic lawyer. I'm not conducting research in politics. So some of you may be familiar with more about geopolitics of the data. But Japan has been promoting a data free flow with trust in terms of as a political will. The US has been, according to the former German Chancellor Merkel, delivered her speech at the Davos meeting. US has a very market-oriented approach in terms of data governance, whereas China has been very progressive in terms of the surveillance and the management of personal data by the the national government. However, Europe has been respecting the human dignity or humanity in this algorithmic society. So how can we balance, strike a balance these geopolitics in terms of data flow? Data-free flow with trust is a concept which was delivered on the same day of adequacy decision at the World Economic Forum. Then Prime Minister Abe stated, data-free flow with trust is a concept that we must protect the privacy and personal data, while we have to open completely no barriers at all, like non-personal data or medical data or any industrial data. So Japan is going to host a G7 summit this year, as I mentioned. Japan has been contributing to the OECD Declaration on Government Access to Personal Data. This is a government access issue. Also, the digital minister delivered his speech several times in these few months, mentioning that Japan is promoting Japan is going to establish a new international body with a permanent secretariat in terms of data flow. This would be tabled for the May G7 meeting. And the PPC, Japan's Personal Information Protection Commission, issued a global strategy last March, almost 1 year ago, mentioning the possible establishing a global corporate certification system. As I understand correctly, the European EDPB issued a first certification mechanism, the Euro privacy certifications last year. In terms of the US attitude about certification, US has been pushing the Apex CBPR certification, but Japan has only 5 companies so far which were certified as Apex CBPR rebels. These are the overview of my research, and thank you for your kind attention.
Thank you, for Professor Hiroshi, for that excellent presentation. Now we move to Dr. Svetlana. Over to you.
Thank you for having me, and I apologize if I start coughing during the presentation. I got a terrible cold, and sometimes it prevents me from speaking. So my research was, the goal of my research was to apply with trade agreements that Japan has recently joined with data flow provisions in them, to the restrictions on data flows that are imposed on Japan by the EU adequacy decision. And of course, there are a lot of trade agreements that Japan has recently concluded that have rather similar provisions, but if you look closely at them, they do vary in wording. So in my research, I was asked to focus on two agreements in particular, the CPTPP and the US-Japan Digital Trade Agreement. Yeah, so in my presentation, I will focus on the cause of the tension between the two, between the adequacy and the trade agreements, on the essence of the tension and the implications that this tension might have in practice. And I must say that my report and the outcome of my research is rather detailed, because I looked at the specific trade rules and their potential interpretation with reference to specific case law. So I will try to keep my presentation a bit more high level, and if you would like more details, you can find them in the more detailed analysis in my report. So as Hiroshi already explained, Japan has shaken hands with many different parties, and one of the important achievements for Japan in terms of EU-Japan data flows is, of course, the adequacy decision for Japan that the European Commission adopted in 2019. And also, I think the important part of it is that the adequacy decision for Japan is the first adequacy decision after the GDPR was adopted. So the standard for adequacy has been increased quite a bit compared to the directive, and the adequacy decision for Japan is much more elaborate and has much more requirements on also onward transfers of personal data, EU personal data from Japan, compared to other adequacy decisions. And so this adequacy decision created a free flow of data from EU to Japan. And the idea is that the protection of the EU General Data Protection Regulation travels together with EU personal data to Japan. And if that EU personal data goes to any other country, a third country, then the protection follows again. And on the other hand, Japan has joined several digital trade agreements, and two of them I analyzed more specifically is the Comprehensive and Progressive Agreement for Trans-Pacific Partnership and the US-Japan Digital Trade Agreement. And both of the agreements contain binding legal provisions that require Japan to maintain free data flows to the US, so the US-Japan agreement, and to a number of other countries under the CPTPP. So here is a graphical representation of the potential tension between the two data flow areas, and Japan participating in both of them might feel the effects of that tension. So the adequacy decision for Japan imposes or analyzes Japan's rules on transfers of personal data from Japan, and includes several restrictions on onward transfers of EU data from Japan. You can see them on the slide. So this is a toolbox of measures. Only one of them is sufficient to ensure that protection travels with the data, at least in the view of the European Commission. So it is consent, individuals' consent equivalency assessment by the Japanese Data Protection Authority. And to my knowledge, this equivalency has only been afforded to the countries of European Economic Community. Please correct me if I'm wrong later on, or maybe to the UK as well. But there hasn't been many countries that this equivalency has been afforded. And there are binding private law agreements between data exporter and importer, so something like standard contractual clauses or other contractual arrangements. So if you look at the cross-border data flow obligations in the CPTPP and US-Japan Digital Trade Agreement, they're quite broad. And in my view, restrictions on onward transfers of EU data from Japan clearly fall within the scope of these provisions. I also analyzed the scope of the digital trade chapters in which these provisions are situated. And I think because those restrictions on onward transfers clearly set barriers to the flow of information from Japan to the parties of the CPTPP and to the US, there is a clear-cut case of violation of these provisions. However, a violation of these provisions per se is not in itself a problem, because both agreements contain certain exceptions that could justify that violation. And if that happens, then there is no problem. So both agreements provide for some flexibility for the members, for the parties to those agreements to deviate from these obligations. So I put, because these exceptions are formulated slightly differently in both agreements, I put the exception from the CPTPP on the slide. And basically, the structure of this exception follows roughly the structure of the general exceptions from the WTO agreements, in particular, the General Agreement on Trade and Services. And it requires a two-step assessment. First of all, it has to be established that restrictions on transfers are necessary or are not greater than are required. So the so-called necessity test. And the second step is the so-called chapeau or introductory clause, is whether the restrictions are applied in a manner which would constitute a means of arbitrary or unjustifiable discrimination or a disguised restriction on trade. Of course, this wording is slightly different from the wording in the WTO agreements. And in my analysis, I built argumentation based on that interpretation at the WTO, because there is really no other case law at the moment that we can rely on. And that is one of the uncertainties when it comes to the application of those provisions in practice. It is also important to flag that both agreements contain a specific article on personal information protection, which sets also the wording deviates, but the idea in both cases is setting certain minimum requirements for the protection of personal data. So the standards for the protection of personal data set forth in these articles is rather low, especially compared to the standards in the EU GDPR and in the adequacy decision, but also in the Convention 108 on the protection of personal data that Hiroshi mentioned in his presentation. So this article, it could be relevant in the interpretation of the exception. I'll just a few points on the application of the necessity test. The key question is whether the restrictions on transfers of personal data are, if there is a less trade restrictive alternative to the restrictions on onward transfers of EU personal data that is reasonably available to Japan. So clearly there are other less trade restrictive mechanisms, for example, the OECD standards or the APEC privacy framework or the CBPR framework. The question is whether these less trade restrictive measures or mechanisms are reasonably available to Japan to ensure the same level of protection. And here, of course, the key is the same level of protection, which is quite a tricky thing to measure, because in practice, it's really hard to evaluate what the actual level of protection is, because the rules can require one thing, but if there's no enforcement, the level of protection in practice can be much, much lower than it is declared. And there is a lot of uncertainty around that. And I think in case of Japan, the problem is also that Japan has endorsed the OECD standards, and in their guidelines on cross-border transfers of data, also endorsed the APEC privacy framework as a relevant international standard, which kind of suggests that it could be argued that these other alternatives are reasonably available to Japan, in the sense that Japan does not see them as very different from their own framework. And that is, of course, not the view of the EU, which in the adequacy decision stated explicitly that the APEC, CBPR, and the privacy framework are insufficient to ensure adequacy. However, for the trade assessment in the trade adjudication body, whatever the EU said or wrote in the adequacy decision is irrelevant. Now, the chapeau is basically the standard of good faith and prohibition of abuse of rights, but there are certain clues in WTO case law that pin it down, that clarify it to certain circumstances. So it is considered that the party is not in good faith if it requires equivalent standards in all the parties to the trade agreement, but I don't think this is the case for Japan onward transfer restrictions, because there is not only equivalency assessment, but also consent and contractual measures. Then another manifestation of bad faith is that the contested measure, that the application of the measure does not consider different circumstances in different territories. So the restrictions on onward transfers, they apply to any third country without distinction of what the actual level of protection is in all those third countries. And that also Japan failed to negotiate with each of the CPTPP parties, for example, also some framework for data transfers, as opposed to just applying the same one-size-fits-all mechanism as it is required to do under the adequacy decision. So all in all, there is a risk that restrictions on onward transfers of EU data from Japan violate both CPTPP and the US-Japan Digital Trade Agreement. And there is also a risk that these violations may not be justified by the exceptions, which means that Japan would have to choose whether to comply with a decision if there is a decision of an adjudicating body under the CPTPP that Japan is in violation and exceptions are not applicable. Then the Japan either would have to comply with the decision, and that would probably mean losing adequacy, or to comply with adequacy and remain in violation of the trade agreements, which is also not unheard of, because both the EU and the US did not comply with all WTO decisions, for example, and just accepted the trade retaliation measures of non-compliance. But there's a cost to this. And another important point is that legal effects of a breach of a trade agreement are not automatic. So they don't have direct effect. If Japan is found in a violation of a trade agreement, it would have to implement it in domestic law. And that comes with a choice again, where if Japan implements, then it might, its legislation may no longer comply with the adequacy standard. But then from the EU perspective, this is not a real practical problem until Japan actually implements changes its legislation to the extent that it no longer meets the adequacy standard. And of course, it's not a problem for the EU as long as the withdrawing of adequacy is a credible threat. And from other adequacy decisions and their review, I can see that revoking adequacy is actually not a real threat, because some decisions are under review from 2017 and are clearly not up to standard with the GDPR, and nothing has happened. And I think the situation, the tension between the EU adequacy requirements and trade agreements is certainly a point of concern for other countries like Canada, New Zealand, and the US that also, and the UK, sorry, that have signed up to trade agreements with similar data flow provisions as Japan did. So there are also certain constraints to the analysis and to the risks. And the first one is that the US-Japan DTA, Digital Trade Agreement, has no enforcement mechanism. There could be that this agreement is a part of a broader trade negotiation between the US and Japan, and there would be a adjudication mechanism later on. But it is possible that the US might retaliate against Japan through its domestic regulation if Japan restricts the data flows. Another point, of course, is that the US and Japan, that the US and EU have found a consensus on transatlantic data flows, and the EU is in the process of adopting an adequacy decision. So in this case, the flow onward transfer of EU data from Japan to the US might be less of a problem to companies that have self-certified under that transatlantic mechanism. Then there is uncertainty of interpretation, which I already mentioned. And of course, there's also politics, that not all cases of violation of trade agreements end up in settlement, in dispute settlement, in trade adjudication bodies. But at the same time, there is a chilling effect on domestic regulation, and the very risk of violation or trade dispute might prevent countries from adopting certain legislation or acting upon them. With this, I conclude my presentation, and thank you very much again. I'm happy to answer questions afterwards.
Thank you, Dr. Svetlana, for that excellent presentation. Now we move to Javier, over to you.
Yeah, I'm just going to try to share my screen. Hopefully it works. Then, as usual, yeah. Just find the show. Yeah, can you see me on the slides? Yeah. All good? Hi, yeah, so yeah, my name is Javier Ruiz, and I'm going to basically just wrap up following in a much even top level summary, or following from Hiroshi and Svetlana's presentation, just to give you an overview of the project. You know, I work as a consultant trying to put the project together and helping with the broader research. So I'm just going to give you an overview. So as we said, you know, what we tried to find out, as we said before, was to look at whether strategic litigation in this context made sense because of all of that. But the main reason why we wanted to do that was because this idea of interoperability it looks interesting and useful on paper, but what we are finding is actually that in fact can be used to lower standards and to lower consumer protections. So the main concern is that if the EU is not enforcing its adequacy decisions, is letting countries develop parallel regimes, and by the time that consumer organizations around the world try to get a grip on all this web of trade agreements that are enabling data flows to lower standards, is going to be very difficult. So the idea of upholding the higher European standard is mainly to help privacy around the world. So, I mean, just to give, I mean, I think that I know that, Hiroshi and Svetlana gave a very good, detailed presentation, but just to simplify what we have here is we have these two data regimes, where one with the European Union, that say data flows are permitted, and the other one with the US and other countries that says data flows must not be restricted. But at the same time, the adequacy decision says that EU data flows must be restricted. So there is a supplementary rule that actually specifically blocks those data flows. And I think what we are finding is that in that context, this puts Japan in a quite difficult position. So for us, the questions that we wanted to ask was, does the legal insecurity void adequacy? Is that a basis for challenging adequacy potentially? As Svetlana looked up, is it proportionate for Japan to block APEC, after agreeing that they're equivalent to the GDPR in their trade agreements? And also, does a bilateral trade agreement trump adequacy? I mean, you have these two, seemingly incompatible agreements, so it's a little bit difficult to, it's hard to understand which one applies when you have the conflict. And the one thing that is, as Hiroshi explained before, the one thing that can jump over the barrier set up by the European Union between Japan and the US is the use of consent. But then, as Hiroshi explained, the use of consent can have problems because there is not enough transparency potentially in some cases. So the thing that's also important is to understand what the research was not trying to do and what this project very specifically was not trying to do. So very clearly, we were not trying to protect the privacy of Europeans or over people in Japan, and to say, this is about, the rights of Europeans being violated, or even or the rights, or to protect Europeans against Americans or other countries. Definitely not about undermining the EU framework, and making it impossible, and definitely even less so about imposing the EU approach on other countries. I mean, I think it was very important to work with civil society organizations in the region to make sure that this was not the case. And the other thing that I think is important to remark, is that we love the internet, and we definitely did not want to restrict personal data flows as long as they have adequate privacy and consumer protection. The other thing that is worth mentioning, although Hiroshi mentioned a little bit restrictions on AI and the new policies, and I think that those are issues that were not really in the core of the scope of the project. Like, for example, how data flows may enable fair technology transfers, like the use of data for training AI and other innovation policies and strategies. And also, although it came into the discussions, we didn't want to focus so much in the digital trade with China, because the set of agreements in that context are quite different, but of course, all those are very important things and very relevant, and we are very interested. We just didn't put them at the core of the project. So again, why Japan? That's been, I'm again recapping a lot of the slides from Svetlana and Hiroshi, but just to point, Japan really has connections with all of those spaces. I mean, the EU now has an adequacy decision with Korea, but Korea is not in the same CPTPP framework exactly. It's in the CBPR, it's in APEC. There are all these different regimes that overlap, and Japan really is at the core of those. So that's very important. The other reason why Japan, again, to summarize, Japan is a leading actor in global policy, is one of the main actors of the World Trade Organization in promoting the new e-commerce agreement. In the G20 in 2019, Japan proposed the data free flow with trust. And as we said now, as Hiroshi remarked, the World Economic Forum specifically, it's maybe, or other institutions may become a permanent secretariat for this. So the research, just to summarize, the questions that we wanted to ask was, we wanted to look at the Japanese privacy regime, the reforms and the enforcement, which is the work that Hiroshi did, how Japan's trade agreements and, would conflict with privacy and the exceptions. Then we also looked at the evidence of cross-border data transfers, where we were with Adequacy Consulting, which is a great organization from Barcelona in Spain, who helped us look at some of the mapping, but also devise a plan for further mapping if and when any litigation went forward. Then we also talked to lots of people mainly in Europe, and not only, about how to approach litigation, the need for standing, whether you should have an administrative complaint to a data protection authority, or whether you could go to the CJEU, to the Court of Justice. And we also were very interested in looking at what were the advocacy gaps and strengths in civil society and collaboration. So the outputs, as we mentioned before, they are all in the website, dtalliance.org. And I think that there are, particularly, I would like to remark that the translation of the, and is a very small, like pet interest, but for those of you that work on Japan and data flows, the translation of the guidelines were at the point that we made them were the only available document in English of such an important text, and it was quite invaluable to be able to read Hiroshi's paper. You do need the translation of the guidelines to follow up. So we were looking at the key takeaways to summarize. So as we said before, Japanese data protection framework has improved a lot, but we still have concerns, that it is still a weaker regime, particularly in creating this two-tier regime for EU data, where there are protections, but then there is a parallel regime based on sending data to APEC, to the APEC CBPR regime without consent. And then when it comes to consent, which would be the only avenue left, there are potential loopholes and the enforcement is still weak. So the other thing we found, and actually it's important to mention, is that there is a growing social concern about privacy in Japan, but we also found that global openness is an important progressive value, and that we have to, when we work with, Japanese organizations, we need to keep that in mind. Then the key takeaways, again, summarizing, that's the, almost in a pedagogic value, is that we found that the restrictions were likely disproportionate. So the fact that the EU, or that Japan has committed with the EU to restrict data flows to countries that have trade agreements with Japan that say that the data must flow, could be disproportionate, restrictive, and potentially discriminatory, but that this is not clear-cut. And something that was pointed out is that adequacy is not mandatory, and there are lots of complications, and specifically the lack of jurisprudence. But as Svetlana mentioned, it doesn't look great if only 2 out of 48 applications went through for exceptions. So that's then we also, when we look at the evidence of data flows, to say, look, this is not just a theoretical concern thing. In some of the research that Hiroshi translated showed that some 25% of Japanese corporations in the survey were sending data across the EU, Japan, and the US. And also that all of the top game developers have subsidiaries and affiliates in the US, and in their privacy policies agreed for data sharing with the United States. And also, as was mentioned before, we also have to be aware, that this thing is particularly the APEC transfer regime is still quite limited. Only, I think it was 3 and now 5 companies. But what is telling is that one of those companies, which is Yahoo Japan, which is actually not connected with Yahoo anymore, has stopped EU services to avoid conflicts. And we think that this is quite telling in terms of the potential conflicts. And then in terms of litigation, we talked to almost everyone we talked to agreed that there was a basis and they would be viable. And there were several options, and we can discuss separately. Something that was very important was to avoid a situation like the Privacy Shield, like this impasse where everyone knows that it's wrong, but no one really knows what to do. And then also we found that some of the elements would need to be tested, like, for example, whether a trade agreement or an adequacy commitment, would trump each other. And then it was also pointed, as it was raised before by Svetlana, that there are other countries in a similar situation, New Zealand, UK particularly, and those would be potential avenues for challenge. And something else that is important is the EU may be changing its trade policies, so these conflicts may become even more complicated. And that's something that we may discuss after the presentations. So then just but I think what would be the main takeaway from the project was actually the need for improved civil society collaboration. So in some of the discussions that we have with groups in Europe and the Asia Pacific region, found important gaps. I think everyone has got some understanding of what's happening in China, very much less so of Japan or Korea, and all the innovations that are happening in the region around digital economic partnerships and agreements. And that seems quite important, particularly in Europe, but also globally. Also, any activities would need to involve Japanese civil society organizations. And this is very important, particularly if you're looking at the G7, where, as Hiroshi mentioned, the Japanese government is going to revamp the digital, the data flow with trust, but also the Internet Governance Forum, which is taking place in Kyoto later in the year. And it would be important to build stronger connections with civil society there. So that was it. Thank you so much. And these are the members of the Digital Trade Alliance. It's a global coalition of consumer and privacy organizations. So I said, I work in this project as a consultant. I think I'm very, very happy that I did. I think it was really interesting. But I think if you want to find out more, you can talk to Deepika, or if you may find also that there are some of these organizations operate in your country. Thank you.
Thank you, Javier. And I want to thank all three of our researchers for their outstanding work on this project. And we are now open to take questions from the audience. In the meanwhile, I have questions for our researchers, and I would like to start with Professor Hiroshi first. Professor, like you mentioned in your presentation, and it was quite a highlight during this entire webinar, that Japan, as a chair of G7 this year, is going to push and bring to center stage the concept of data free flow with trust. We can expect this to be potentially a landmark year with the presidency of G7, right? So can you please talk about the concept of DFTT introduced by Japan, and how do you think this will play out in current scenario where countries themselves have tough time regulating data domestically?
Yes, thank you for your question. So DFTT means, according to former Prime Minister's speech, is to put personal data and data embodying intellectual property and national security, intelligence, and so on, under careful protection on the one hand. While according to DFTT, other free flow of data like medical data, industrial data, traffic data, and non-personal data, anonymous data, these should be no border. There should be no borders according to a Japanese government project. And additionally, recently, as I mentioned earlier, a digital minister emphasized the Japanese government is going to establish an international new body focusing on digital data transfer issues with permanent secretariat. So at the first stage, WTO was the possible candidate for the handling a digital trade issue, but due to the questions on the WTO is that can personal data be treated as a commodity, which can be discussed under the umbrella of WTO, as Svetlana has elaborated. So this is, I think, a crucial question. So that's why the Japanese government seemed to change from the initial proposal in 2019 to the this year as an G7 presidency. This is my understanding, but this is all about politics and out of my scope. So, and yes.
Thank you, Professor. We have a question from one of our participants. Valeria is asking, do you consider that the fact that the European adequacy for Japan has been granted only for the private sector and not for the public sector may have any relevance or implication in the analysis of the two tails?
Yes, thank you for this question. So after 2019 adequacy decision, Japan amended twice in these 3 years for our data protection law in 2020 and 2021. So the revolutionary reform of Japanese data protection law occurred 2021 when we integrated a separate private sector law as a APPI, known as a former covering only commercial sector, there are a few public sector data protection laws without any independent supervisory authority, but we changed these systems in order to aiming public sector adequacy decisions from the European Commission. So we are now ready to, knock the door of the Commission to seek both a private public adequacy decision. But as for the second question, are there any two tails? There should be two tails, as we already discussed. There are some missing provisions like profiling issues. And also facial recognition is, I think, a mandatory issue, pressing issue for both the European Commission, EU, and Japan. Also, the supervision and enforcement action, as I mentioned earlier, there's no enforcement action, zero enforcement action until last month. So I think these are crucially important when when the European Commission look into the public sector law.
Thank you, Professor. We have one more question for all the. Yes,
Been on the previous question from the perspective of trade law and Japan law. So I just wanted to emphasize that the 3 data flow provisions and trade agreements, they're also only for business purposes. So they both indicate that the parties must maintain cross-border data flows in the business context. So in this sense, there is no mismatch between the adequacy decision, which is also for business operators, and in the trade agreements, it is also the free data flow for business.
Thank you, Svetlana. Javier, do you want to jump in and anything?
No, I think not in that question. I think that was quite already covered.
So we have a question from Laura Dreschler for all the experts here. How do you see the role of individuals in these questions on data transfers, trade agreements? For example, what kind of legal relationship do individuals have whose data are transferred under either the adequacy or the trade agreements?
Well, may I say a few words on this question? Yes, thank you, Laura, for these questions. I'm sure you are familiar with the Japanese law. There's only one opportunity for an EU individual to seek a remedy for the Japanese PPC, Independent Supervisor Authority. That is making a phone call. This is only one effective way to reach the PPC. But the time differences, and they accept only English. So to the best of my knowledge, the PPC has not published any report regarding even the statistics, how many complaints are receiving from the EU citizens. There's no transparency report at this moment. So I can't say anything about at this moment. This lack of transparency.
Yeah, I mean, I think that is an important question. So just to add in broader terms, I think one of the problems with the adequacy is that when in the European context, if you have a transfer in a context where there is no adequacy, you need to think about safeguards. You need to think about a lot more about whether is the company complying a bit more. Particularly if you are looking at contracts, at clauses, there is a need to define who's got liability. So if I, as an individual, have a problem, which company, and despite, I mean, all those methods or the alternatives to adequacy are in many ways inferior for individuals because they create problems. But now the problem you have is that when you have adequacy that doesn't really work, individuals could be in a worse position because there is an assumption that things work. So you then you are not padding the adequacy decision potentially with so many extra safeguards that you would put, for example, in the standard contractual clauses where you would force the parties to choose, to decide, on issues of liability So I think that that is a particular problem, you know, one of the big problems with adequacy or bad adequacy.
Thank you, Javier. Svetlana, do you want to add to that?
To add a bit of EU perspective. So from the GDPR perspective, the individuals can always approach the initial exporter of EU data to Japan. And well, they can request information about where this data flows and about the onward transfers, etc. And they can potentially also complain to the EU DPAs. But in practice, this doesn't, well, it's very hard to implement in practice because information about transfers themselves is not always very granular, but about onward transfers, it's very, very intransparent. So if you read the privacy policies, for example, you don't find information about onward transfers there. And then, so you have to submit requests, access requests to even find out what happens. But in practice, also the transfers are so complicated. It's not just one-to-one, but it's really hard for companies themselves also to map the transfers. So I think in practice, once the data left Japan, it's really hard to enforce the compliance with the adequacy decision and the standard of the GDPR. And this is not just for Japan. I think this is for all the adequacies, as Javier mentioned, that the onward transfers is the weakest spot of the adequacy mechanism.
Thank you, Svetlana. I know we are over time. I have one more question, and I think we can wrap it up while answering this question. Do the panelists see a potential conflict between the EU's position on cross-state border data flows promoted at the WTO e-commerce negotiations and the conditions it sets in its adequacy decisions?
Well, I think what the proposal itself says, it has quite a broad exception that allows the EU to justify. First of all, the provisions on data flows, the obligations on data flows are much narrower than the ones that I discussed, so they're much more granular. But even if the EU adequacy or the transfer regime under GDPR violates those provisions, there are quite broad exceptions that I think in the way they're proposed are sufficient to justify whatever the EU is doing under the GDPR in terms of transfers. The problem with that proposal, I think, is that it is not very clear what the relationship is with the general exception. So each of the agreements, and of course the GATS in the WTO, has a general exception for privacy and data protection, which is much, much narrower and which may not be sufficient to justify the EU regime. And I've seen that I think in the EU-New Zealand data flow provisions, the EU specifically included the relationship with the general exception. And I think that would also be necessary for the WTO negotiations. But in practice, we don't know where this negotiation is going to go. We might also end up with a type of provision that is in the EU-UK agreement, which has much lower safeguards compared to the proposal the EU submitted to the WTO. So yeah, I think it is sufficient to be short, but it has to be also clarified how that exception works together with the general exception, and to avoid the risk that the general exception will be applied instead in certain circumstances.
Mm-hmm. Yeah, if I can add, I mean, I think that's something that that is important. Going back to the context of the project, is that the changes may work to protect the European Union regime. I mean, I think that is so from a defensive point of view, some of these things may work. Now, the question that for a global project like the DTA, what we are also interested in is in how these changes may actually weaken the global edifice of data protection, and I think that that is where we are having potentially more complicated a more complicated situation, because the EU seems to be, well, within the EU, which is not call it the bloc, but it's not really a monolith. There are different competing interests, like pretty much like in Japan. There are also like people more interested in trade, and others more in fundamental rights, or geopolitics play a huge part. So I think that there are, apart from the conflicting, the one concern is that even if you manage to safeguard short-term the interest of the European Union to self-regulate, in the longer term, you are weakening your overall approach to data as a fundamental right, or to the rule, or to the rights-based regulation. So I think that that is the broader concern that would have impacts elsewhere. Yeah.
Thank you, Javier. I think, Javier, do you want to wrap it up by sharing the biggest achievements of this project briefly?
So, I mean, I think, as I said before, I think for me, the biggest achievement is having, in many ways, like what this, well, I think our panel in a way encapsulates a little bit, like what we have achieved, which is to be able to connect with colleagues in Japan and also broader Asia-Pacific region, like Korea and other countries, to really understand, in a lot of detail, the situation there, and to find like a lot of common ground, and to enable future collaboration. I think that obviously the litigation was something that was very interesting for the project, but the litigation in itself, without this form of, without the broader advocacy change, would not be that useful, because what could simply create is a situation where people in Japan felt either attacked directly, or where you would end up in a situation that was not practical. So litigation would make sense in this wider context. And in that sense, I think that for me, the most exciting thing is to continue collaborating with organizations in the region.
Thank you, Javier. First of all, I want to thank all the participants who attended this webinar and for the excellent questions. I want to thank our panelists for the excellent work that they have produced. And once again, all the research and all the documents and the blogs are available on the DTA website. The link is available in the chat box. A recording of this webinar will also be available on the website. And thank you, everyone, and we will see you soon with the next webinar.
Thank you.